Can anybody hear me?
I can hear you.
Oh, good. Okay.
Sorry, I was setting up the YouTube.
Oh, no,
Yes.
that's okay. I just wanted to make sure people can hear me today. Okay.
So then, congratulations, you survived day 3.
Yeah, I think we're gonna finish today.
Yes, it's nice.
Yeah.
Mm,
It's nice when things go as planned. I'm sure for everybody.
yeah, it's true.
Yeah.
All right, I'm gonna mute my microphone because there's noise here.
Sure.
How are we doing, Melissa?
I'm here. Trying to get myself together.
Okay. Great.
It's harder and harder as the week wears on.
It is, isn't it?
Yeah.
I know. I was here till 6:30 last night. It's like, can I go home now? We're on YouTube already.
Perfect.
Anna is taking care of that. Do we have any procedural issues that we need to deal with this morning? It's good. It's good. Not hearing that we do. Mr. Najjar, are you gonna put your clients? I'm gonna ask you if your client has a position and if you're gonna file anything or not.
We presented the stipulation to our utility board and they voted to approve it, but we still have to go to the council. And so it's a matter,
Okay.
I don't know what the timing is because I can't control the county council's agenda. But
Okay.
so we officially remain unopposed to the stipulation.
Okay. All right, we can put that.
Sure.
We can put that on the record. I think one of the things that we're going to need to clear up before we conclude our hearing is the responses to the bench requests. And I believe I had it confirmed last night that that I put the responses to the bench requests that gas company filed yesterday in the Dropbox, and that people were able to access those. And no, I don't know why my folder has a subfolder with a subfolder. Don't know how that happened. But I think that the parties could get to them. So we just need to make sure that we formally have the opportunity for the parties to formally state their positions on the bench requests. Okay. All right. Well, we're almost ready. I've got about 2 minutes. Melissa, you tell me when you're ready. And
Okay, I was just gonna tell you, I keep seeing Miss Beadle's audio just like she's trying to get on but can't quite get on or something.
okay.
I don't know if you're seeing that, but I just wanted to report that. And I'm ready whenever you are. Just say on
Okay.
the record and I'll get moving.
Okay. No, I see that she's trying to connect too.
Yeah.
Good morning, Mr. Borman.
Good morning, Madam Hearing Examiner.
I'm just trying to ascertain whether or not we have any procedural issues before we go on the record. And
The only procedural issue that I'm aware of, I think you probably dealt with it yesterday, regards Mr. Wataro's testimony. As I understand it, his testimony is being waived.
his testimony is going to be stipulated into the record.
Okay,
His appearance is being excused.
understood. Okay, thank you.
Ah. And I was just saying that one of the things that I think that we need to do is just make sure that these bench request responses, parties have an opportunity to object and or hopefully not recall the witness and cross-examine. But Mr. Dome?
Yes, on the outstanding bench request, which is number 6. We have received a draft and we're working on it, and so we're hoping to be able to turn that here in the next hour or so. And maybe we can get that filed with you before noon.
So
That's the one about
I
the,
guess we're gonna need to go through the numbers because like I have 5 and 7 in front of me. I know you filed those yesterday.
yes.
And I think we've already admitted 4.
Yes, ma'am.
You actually said the words admitted on 5 and 7, because I didn't show that. On bench requests, I'm talking, unless they're an exhibit. Okay,
And they are.
okay. Oh, because I have
Well-
18. 18 was a bench request. Isn't that a bench request? Yes, it's a bench request.
Response to the second bench request.
Right.
Okay,
But so how I'm picking them up and indexing them is if somebody says it, well, not somebody, when hearing examiner says thus and such is admitted, I tag it there. So if you're calling it by bench request 4 or whatever, it indexes that way. But when number 18 was admitted, if that's a response to a bench request, I just, tag it there. I don't even know if you know what I mean, but
So, Madam Hearing Examiner, what I understand where we are is that you've admitted the first bench request as Commission Exhibit number 2. You've admitted the second bench request as Nmgc Exhibit number 18. You've admitted the third bench request as Commission Exhibit number 1. And then we admitted the bench request number 4 yesterday as bench request number 4. You have
yes.
not admitted 5 or 7, but you have those. We sent those to you yesterday. And 6 is the one that WRA is working to try to get a joint response. That's bench request number 6. That one is the one that we're working on to get to you by today.
okay.
And then that would cover all 7 of the bench requests that I have any record of being in this case.
And does that make sense to you, Melissa?
Yes,
Okay,
yes, because I don't show, I only have, for yesterday, I had 18, and then I had bench request 4. And
mhm.
I think on day 1, I was just checking that, day 1. And I think we had commission 1 and 2, but those
Yes.
aren't, okay, so I'm kind of counting those. And then I had knee
Yes,
bench requests on day 1, I think I had.
yes.
So I think
Yeah.
I'm with you. I think I'm
Okay.
understanding. I
Great.
am. I don't
No, I
have as
think-
much, I don't have as much education as everybody else, but
You are integral. We can't do what we do. So, without your knowledge and experience, Melissa. So it sounds like that we're on. I think that was a very nice recitation, Mr. Dome. Thank you.
Thank you, ma'am.
Yes.
And the company has no objection to the admission of bench request number 5 and 7, obviously.
Okay. And I think putative exhibit bench request 8 and 9. I asked Mr. Buchanan about yesterday.
Yes, ma'am. That's
So, okay. Because I didn't actually get to the point of making bench requests on this. Great. Well, I think we've got all that straightened out. And I don't know if somebody wants to give Miss Beatles
Disconnecting.
well,
Yeah.
it's been saying that for 10 minutes.
Ah,
I
So,
wonder if she should call in on a phone line or on her phone, if that would be easier. I don't know. Sometimes I
said-
see people default to that.
Yeah, Madam Hearing Examiner, she sent us an email yesterday that she was just waiting in the waiting room, but I think this looks different than that.
Yeah,
no, I don't have anybody waiting in the waiting room.
Oh, okay.
no, yeah, she's trying to get audio and so she's having a problem on her end.
Yeah, no, I don't see anything except she's trying to connect to audio.
Madam Hearing Examiner, this is Dan. I just talked to Sydney and she's going to try to call in on a phone.
Okay.
She said they've been trying to connect for minutes, several minutes. So she will dial in.
Thank you, Mr. Nazar. Appreciate that.
Madam
Um,
Hearing Examiner, Tom Domi again.
Yeah, I'm
So
just
I
going to
was-
remove her from the Zoom. Yes, sir.
So ma'am, I'm wondering, were you going to admit bench requests 5 and 7? Because they're not in yet. They're not in.
Right. We have to go on the record for that.
All right. Just getting clarification.
Okay. Great.
Maybe while we're waiting, I'll ask, but number 6, bench request, response to bench request. You haven't admitted that either. That's coming and we'll do that one too. Today.
Right. Hopefully we get that one for our record. Yes. Okay.
Yeah. and Sydney-
Now she's back in the waiting room again.
Oh, good.
Okay.
And so Sydney did not hear what I was telling her about 6, and so she would probably want to hear that because
Yeah.
that's the one we're working with her on.
She's there.
Okay. All right. Miss Beatles.
Yes, we still haven't worked out all the kinks. Thank you.
Mr. Dome was just saying that you all are still working on response to bench request 6, and hopefully we'll have that before the close of our hearing. Okay.
Yes,
Okay.
yes.
All right. Very well. Okay, I think we can go ahead, Melissa, and go on the record if everybody's ready. We are streaming live on the YouTube, and we have had some procedural discussions about exhibits and maintaining our evidentiary record. And now that we are back on the record, there are a couple of things I just wanted to find out before we begin the presentation of staff's witnesses. And the first, Mr. Najjar, I know that the pleadings had indicated previously that your client has a voting duty with regard to any position that you might take, and you hadn't formally weighed in as a signatory, but I believe your the prior position was that you were not opposed. So if you could just let me know on the record, Mr. Najjar, what your client's position is.
Thank you, Madam Hearing Examiner. We have a 2-step process before we can join a stipulation. We've completed the first step, have not yet completed the second step in front of our county commission. We do not oppose the stipulation. We participated in all the negotiations. We remain unopposed, and I still hope to get approval shortly to join it.
Very well, sir. Thank you. Have parties had the opportunity to review what I put in the Dropbox after the close of yesterday's hearings and what gas company had filed and served on the parties. The first being gas company's response to the 5th bench request. And bench request 5-1 was provide confirmation that gas companies' discounted transportation rates exceed the variable cost pursuant to 17.10.660.10 F8 Nmgc'S. And the response was by Mr. Bullard. Does anybody object or want the opportunity to question pursuant to the rule this information? Hearing nothing, I'm going to go ahead and admit gas company's response to my 5th bench request. And that is basically labeled as bench request 5. The other filing that we got yesterday, and which was included in Dropbox, was gas company's response to the 7th bench request. And bench request 7-1 was, please explain how non-discounted transportation customers are charged versus how discounted transportation customers are charged. Verify the charges for all transportation customers. Again, Mr. Bullard answered that bench request, and it was put in the Dropbox. Do any of the parties have any objection to this being introduced into our record, or want to request the opportunity to question or respond to this answer? Hearing no objection, I will admit gas company's response to the 7th bench request into the record. And again, that's just what its title is gas company's response to 7th bench request. So those two items are admitted. And I believe then with that, we are ready to go ahead and begin our evidentiary hearing with staff's presentation. Mr. Borman, and I've already, good morning, Mr. Malden, how are you?
Morning, I'm good. How are you?
I'm very well, thank you. Melissa, would you swear Mr. Malden in, please?
Raise your right hand. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you.
Thank you. Mr. Borman?
Thank you. Good morning, Mr. Malden.
Morning.
By whom are you employed and in what capacity?
I'm employed by the New Mexico Public Regulation Commission as a senior public utilities economist within the Utilities Division Accounting Bureau.
As part of your duties in that position, did you review the rate application submitted by New Mexico Gas Company in this proceeding, along with the testimony filed in this case?
Yes, I did.
And based upon that review, did you prepare or participate in preparing testimony regarding that application?
Yes.
Now you have a document that has been marked as Staff Exhibit 1. Can you identify that document?
Yes, that is my prepared direct testimony in this case.
Okay. Was Staff Exhibit 1 prepared by you or under your supervision?
Yes, it was.
Okay. Do you have any changes or corrections to that testimony?
I do not know.
Okay. Madam, oh, do you have exhibits attached to staff exhibit 1?
Yes, I do.
Okay. Could you tell us how many?
Yes. Sorry, 1 second. I have to pull up my testimony. I know I had quite a few. So. Looks like I have 10 exhibits and 1 and 2 appendix.
Okay, thank you. Madam Hearing Examiner, I move admission of staff exhibit 1.
I'm sorry, Mr. Molden, the answers are true and correct to the best of your knowledge?
Yes, ma'am, they are.
And if you're asked these same questions today, your answers would all be the same?
Yes, ma'am.
Understanding that there's a stipulation.
Yes.
Very well. Any objection to what's been identified as staff exhibit 1? Mr. Malden's direct testimony as verified by him here today. Hearing no objection, staff exhibit 1 is admitted. Mr. Foreman?
Thank you, Madam Hearing Examiner. Mr. Malden, you are aware there's a stipulation in this matter?
Yes, I am.
Did you review that stipulation?
Yes, I did.
And based on reviewing that stipulation, did you prepare testimony regarding that stipulation?
I did, yes.
Okay, you should also have a document before you that's marked staff exhibit 8. Do you have that?
I do.
You identify staff exhibit 8?
That would be my testimony in support of uncontested stipulation.
Was staff exhibit 8 prepared by you or under your supervision?
Yes, it was.
Do you have any changes or corrections to staff exhibit 8?
No, I do not.
If I asked you today the same questions as are set forth in staff exhibit 8, would your answers be the same?
Yes, they would.
Are those answers true and correct to the best of your knowledge?
Yes.
Do you adopt staff exhibit 8 as your sworn testimony in this matter?
I do.
Thank you, Madam Hearing Examiner. I move admission of staff exhibit 8.
Thank you, Mr. Foreman. You had an attachment to your stipulation testimony, Mr. Malden?
Yes, I had 2 exhibits attached to it.
And you prepared those, or those were prepared under your direction and control?
Yes, ma'am.
And those are true and correct to the best of your knowledge?
Yes, ma'am.
Very well. Any objection to what's been identified as staff exhibit 8, Mr. Malden's testimony in support of the stipulation as verified by him here today? Hearing no objection, staff exhibit 8 is admitted. Mr. Borman?
Thank you, Madam Hearing Examiner. Mr. Malden is available for cross-examination.
Very well. I don't believe that anyone has any cross-examination for Mr. Malden. However, I do have some questions for him. Sir, part of your direct testimony in this case and responsibility involved reviewing the revenue requirement for a gas company and making adjustments?
Yes, ma'am, I did.
And it's the staff's position and it's your position that the original request of in excess of $48 million revenue deficiency was not reasonable, correct?
Correct, yes.
And as a matter of fact, with the adjustments that you proposed in your direct testimony, you actually recommended that there be an approximate 17 million plus decrease. And your recommendation was that the revenue deficiency be set at $30,652,652,604, correct?
Yes, ma'am.
And I'm just looking at your summary at the bottom of page 12. So the ultimate stipulation of $30 million that was agreed to in this case is pretty close to that recommendation, correct?
Yes, it is.
So you're feeling pretty good, right?
Yeah, I'm definitely happy with the outcome of the negotiations.
Okay. And to arrive, you have a table on page 13 that's called Staff Table JBM1, the revenue requirement summary. And basically that indicates how you came up with your number. Looking at the big picture, correct?
Yes.
And there were also adjustments to the specific categories of the application, and those are listed in your table JBM2 on page 14 of your direct testimony, correct?
Yes, that is correct.
And if you proceed to go through the different categories of adjustments that you think that the commission should make. And if you had to pick what were the major components other than the decrease in, I don't believe that Mr. Tupler recommended the same ROE as the company. So I know that would have been a pretty substantial decrease, but what in your mind, where did you, where's the major deficiency components of staff's recommendation?
Okay, so the probably 3-4 biggest adjustments that we made, excluding the ROE, which was another big one, but you already covered that one, would be removing the financial incentive from the STIP, decreasing the labor O&M escalators, adjusting the number of vacancy positions, and the removal of the COVID regulatory asset.
Well, let's start with that one. What was the recommendation for you were taking out, was it approximately $5 million?
Yes, we removed it from rate base as well as the amortization expense. And the biggest reduction came from removing the amortization.
And you I don't know, were you listening yesterday when I was talking with Miss Crane?
Yes, ma'am, I was.
And I meant to ask that question of, excuse me, of Mr. Buchanan, I forgot. So I asked her, but the question actually, the point came from your testimony on page 26. Right?
Yes, ma'am. Yes.
Because staff took issue with the difference, as you say on page 26 at line 4, P&M and gas company have a 2.9% difference in the number of residential customers, but there's an 82% difference in the amount associated with each company's COVID-19 request, correct?
Correct.
And then you say at lines 8 and 9, staff would like to know why there are such large discrepancies between the two companies. Did you do any discovery?
I don't believe that we did. This kind of came to our attention later on in the testimony development process. So unfortunately, we did not get to ask any discovery questions regarding this. That we would have definitely liked to, but no, fortunately not.
So then basically this inquiry is being subsumed in the $30 million settlement.
The COVID reg asset recovery of it. Yes, ma'am.
But you're still confident, not knowing the answer to that question, that the treatment of the COVID-19 asset, specifically in the stipulation, and as it relates to the $30 million revenue deficiency agreement, you're still okay with that?
Yes, ma'am, I am. And I am okay with it because really, I mean, there's no guarantee that the company would recover all of the whole balance. Like for example, with their previous rate case expenses, regulatory asset, they amortized that over 2 years from the previous stipulated case. And in this case, there was still a balance left. So there's no guarantee that they would be able to recover the whole thing. And the stipulation states that, after the 2 years in the next rate case, all of these balances will not be relitigated and considered collected.
So it's a timing. It's not just a consideration of the amount, but what the commission should also be thinking about when it views these regulatory assets that are included as a group in that paragraph. We need to consider the actual timing of the potential recovery.
Yes, that is true. And I believe Ms. Crane kind of touched on this topic as well. I mean, the company may not even choose to recover that asset within that $30 million. So it's really up to their discretion and how they strategically want to use the $30 million that they've been allocated.
And I think that's an interesting point. So, and when I say paragraph I'm talking about paragraph 18, aren't I?
Yes.
Uh, Interesting. I think that's a good point. It's not actual recovery, it's potential recovery within that time period. Correct?
Correct. And once that time period is up, we essentially get a clean slate, barring the Hansen CIS regulatory asset, which I really view as a positive moving forward.
Okay. And the short-term incentive program compensation was also something that you just identified as being a large part of staff's adjustment. Did you remove the whole amount of the STIP?
I believe we removed the financial incentives only. And I believe our amount that we removed was very close to what was identified in Mr. Buchanan's testimony in support of the stipulation. It was right around the 3.6 million. Very
Okay.
comparable.
And then another bigger item comprising the revenue deficiency adjustment. You indicated were the labor escalators.
Yes, ma'am.
In my understanding, you were testifying that around pages 43 and 44 of your testimony. And the sort of the takeaway I got was from page 44, line 8, you say fundamentally, staff can test whether the evidence in the record definitively necessitates that the company be awarded labor escalation for this wage parity aspiration. That's your testimony, sir?
Yes, ma'am.
So you didn't think they proved it? That they didn't prove I guess the link between how that amount of an increase would solve their problem, or
I think there's,
what?
sorry, I didn't mean to interrupt.
No, that's okay.
I think kind of our fundamental kind of concern was the lack of support. Like we thought I believe the Mercer study for the increase was valid and a good resource, but there was a lack of support for the additional increase, which I think came out to like a cumulative 17% increase to base salaries, which I think the company had stated that they had requested the 17% to boost their base salaries to the median in New Mexico. But that last part, we felt there was a little bit lacking as far as getting to that 17%.
What would you have liked to have seen?
I believe we recommended 5.5% for the test year.
No, specifically, is there some definitive proof that that would have assuaged your concerns, Mr. Malden, or some definitive resource if they had presented evidence pursuant to that metric or whatever that staff would have been more supportive of the request?
I'm sure that there could have been, but I could kind of talk about the inverse a bit. Another reason why we thought the wage increase might have been a little high was because of their hiring activity. It seemed to be picking up, and that was another reason why the company wanted such a large increase to base salaries, was to help them hire new employees and retain them. And through our analysis, it seems that they were doing much better as of recently.
Okay, so you were satisfied that the things that they had already done were potentially working.
Yes, yes.
Okay. Wanted to ask you, just as a policy matter, I know one of the adjustments that staff made, and I'm referring to page 16 of your testimony, removing the existing rate case expenses, correct?
Yes, ma'am.
Based on the information you have, is there a policy or a pattern or practice that utilities have, or that the commission insists on, when it comes to how long they can collect on these rate cases? Or should there be one?
I don't believe there is a policy. And I think it's probably, in my mind, best practice to try and amortize it and get it fully collected before the next rate case. That would be ideal, which obviously is very hard because it's dynamic. It's never really set when they're going to come back in. So.
But the agreement, at least with regard to the regulatory asset paragraph, that 2-year period, I mean, do you think that's, if gas companies coming in every 2 years, I mean, do you think the 2 years period then is appropriate for collection of those expenses?
Yes, ma'am, I do. I think they've been coming in on average every 2 years for the last 3 or 4 rate cases. So I do think that the 2-year collection period is reasonable.
Sir, were you I don't know if I had it yesterday. Were you listening when I talked to Ms. DeYoung yesterday?
Yes, I was.
And she testified about the reduction in the rate case expenses.
Yes, I remember that.
In viewing her her exhibit, let's see if I can. Okay. And I apologize. I've got it. I've got this on. I've got the Dropbox not on my main screen, so I can't share it with you. But you said that you're. So you reviewed, or did you review the most recent projections that Ms. DeYoung had?
I'm not sure that I did that. I don't see that she filed a stipulation testimony. Was it in a bench request?
No, you would actually have, she has corrected testimony that was offered yesterday. That's in the Dropbox.
Okay, yes, I have that.
You have that?
Yes, ma'am. I
Okay.
have it up here.
Okay. Go to almost the bottom or end of her testimony. And this is her exhibit 7.
Okay, I'm there.
Okay. Just looking at that and knowing that staff had had 360,000 in rate case adjustments that it proposed. Does the do the adjustments on this attachment to Ms. DeYoung's testimony give staff some more comfort?
Yep. Oh, sorry. I don't mean to.
Give staff some more comfort, and do these adjustments correspond with some of the issues that you had with the original rate case expenses?
Yes, Yes, ma'am. Definitely the overall expense. I think we had recommended close to 2 million in our direct testimony, which was right around their average for the past 3 cases, I believe. So this appears to be coming in well below that, by almost 500,000. And I do see some similarities in the reductions. Maybe not, 1-to-1, but definitely see some similarities between what we recommended and their updated projected rate case expenses.
Well, and I believe you probably, if you were listening yesterday to Ms. Crane, you had me, or you heard that I was asking her about your footnote 17 on page 22. And I was kidding a little bit, but I really like that illustrative thought there, Mr. Malden. Again, I think that's how perhaps a staff cost-cutting view would be, okay, where can we get food we like, but not break the bank, especially if we're, on a state per diem. I'm thinking that's the glasses that you were looking at that with. Is that correct?
Yeah, I'd like to think of it as reasonable classes. Hopefully.
Okay. No, I think that was great. So, like I say, I enjoyed that. But as you heard, I think it was with Ms. DeYoung actually that I asked that question. That some of the people that are claiming these expenses might like a steak, right?
Yeah.
One of the considerations that I had, I was with you on what's up with the travel expenses, especially if we're doing Zoom hearings. But I don't know that I ever got a definitive answer, except for the travel of one person, I believe that was with the consulting firm that actually had to come and I believe work with gas company on this. So I mean does that seem more in line with it's that going from 180,000 to 28,000 more
Yes.
reasonable?
Yes, very much so.
And you probably have seen me. I want to ask you about this. But I just want to let you know, like I say, that I was having some fun with that, asking that question, because I've eaten at those places and I like those places too. I thought maybe you liked them, that's why you included them. But I thought it was a great comparison, so I compliment you on that, Mr. Malden.
Thank you. Appreciate it.
So here's my you've seen this,
Yes.
the rate case comparisons.
Yes, sir.
And you've testified about the frequency. You've testified about the approximate rate case expense. And I don't know if you heard Ms. Crane's perspective yesterday, when I asked her about just the sort of like the theory of, especially with the frequency of filing, but the theory of, well, maybe if they didn't settle, then there could be some savings. and rate case expenses or something else, maybe they wouldn't need to come in so frequently and they could, it's not just about the rate case expenses, but also it's about, recovery of their costs and being able to fund their capital and run their business, right?
Yeah.
So I think what she pointed out to me in answering that question was that the amount of the rate case expense versus what it actually could be and the benefit compared to just the size of the revenue and the revenue increases basically was worth the effort.
Yeah.
What do you think? Do you have a perspective on how the commission should be thinking about these things, or if they should be thinking about them together?
I mean, I definitely liked Miss Crane's answer. I thought it was very thoughtful. To her point, coming in more frequently with smaller rate increases may be the way to go, with how the company described their capital projects that they have planned, and I believe Witness Shell had talked about that a little bit, versus getting a bigger increase, but also that, I mean, that doesn't mean that they would necessarily stay out for longer. So I think it's definitely a balancing act for sure. And I think it would be interesting to look into it more, or perhaps other things such as like a multi-year rate plan, things of that nature. But I do think that the trade-off of lower increases but more frequent filings is working for the moment, I would say. But it may be, worthwhile to look into maybe some alternatives.
I wanted to ask you about pages 53 and 54 of your direct testimony. Where you're talking about gas companies requested advertisement expense and you made an adjustment to that request of about $50,000, right?
Yes.
However, it was a little troubling to me. You point out on page 54 that staff had requested discovery regarding an itemized list of each of the advertisements, and that gas company had responded that they would file the information in a supplemental response, but you filed your testimony on February 21st and you hadn't gotten that response. Did you ever get that response, Mr. Malden?
I did. I believe we got it maybe a few days prior to filing, but by that point, I couldn't make any adjustments to the cost of service. It's due to internal staff deadlines. So we make the adjustments and it flows on to the rest of the team. So if I were to make any adjustments late in the game like that, it would really throw off our team workflow, if you will. So yes, we did receive responses, but unfortunately, it was too late.
So maybe we need to try to get that information a little sooner next time.
Yes, I believe we filed for the actual discovery, was it our second or third round of discovery? So it was actually pretty early on, and we did wait a while for the response. But to their
Okay.
credit, I think what we asked for was definitely not super easy to get all of that data and, you know, parse it out for what we wanted. So
Okay. Well, I mean, I understand, but you know, $400,000 is $400,000. I don't know how much of that particular, um, I don't know how much of that particular expense was for that category, but you know, I encourage staff to, you know, to try to find out what they think they need to know, and utilize the commission rule process to get that information.
yes, ma'am. And we definitely try to get better with every case. So
Is can you tell me, is this the first time that you've done the revenue requirement with the commission?
I actually did, I believe, most of the adjustments for the P&M rate case as well to their cost of service. So this would be my
Okay.
second cost of service. Yeah.
Are you having fun?
Actually, yeah, I do enjoy going through all the numbers. Sometimes the spreadsheets can be a bit much, hundreds of different tabs that are all interlinked, but that's kind of the fun part of it, kind of decoding it and figuring out the flows.
Is it kind of like a treasure hunt?
Yeah, I think it's pretty comparable.
Um, are, well, so now you've done two. Are you seeing? Were you seeing any differences between an electric company and a gas company with regard to looking at adjustments?
Um, as far as the cost of service, I mean, it was pretty similar. Um, I did have to rely on teammates for that had more experience with the gas company, but as far as the actual cost of service, it was pretty similar.
Let's just briefly take a look at your stipulation testimony, Mr. Walden. You made a general conclusion on page 7. The question posed at line 1, why is staff supporting the stipulation in this case? And your answer begins on line 2. Staff believes the stipulation effectively addresses the concerns presented in gas company's rate increase application, leading to the establishment of fair, just, and reasonable rate. That's your testimony?
Yes.
Does the stipulation address all of the concerns that staff had?
I would say yes. From a big picture perspective, I think I kind of mentioned it in my testimony. You could probably give the cost of service to 5 different experts and tell them to reduce it to a $30 million increase, and you would probably get 5 completely different methodologies to get there. So in that respect, yes, the big picture, I do believe it resolves all of our issues and ends up coming very close to what we recommended. So, but more granularly, there's some give and take, and I think that's kind of implied in negotiations. You give a little and you take a little, and everyone ends up hopefully meeting in the middle. So
Thank you, sir. That's actually a nice segue to my next question. On page 11, you're answering the question posed on page 10. Does the stipulation introduce inconsistencies with the staff's original revenue requirement filed in the case? And in answering that question, on page 11 beginning at line 2, you're pointing out the range of revenue increase recommendations. And then at line 4, you say the $12.9 million range underscores that the agreed upon 30 million revenue increase strikes a fair balance as the revenue increase range leans toward a higher revenue increase with 9.6 million above the stipulated amount and only 3.3 million below the stipulated amount. That's your testimony?
yes, ma'am.
Can we kind of tell me what that means
Okay.
for the
yeah.
record?
So I took some liberty and kind of put together this scenario, and it's kind of assuming that we're looking at staff's proposal in a vacuum with no other intervener's proposal regarding cost of service. And I took my original revenue requirement that I proposed in my direct testimony, and I plugged in the agreed upon ROE and cap structure, which gets
I'm sorry,
us
the
to,
agreed upon, the agreed upon ROE.
ROE and capital structure, sorry. And plugging in the ROE and capital structure, that gets us to the low number, the 26.7 million. And then if I put in the reg assets, assuming a 2-year amortization and they're in rate base, which may not be the case with the company's actual allocation, but that gets us to the 27.02 million. And then if I were to just say that only those were accepted, the ROE, capital structure, and the treatment of the reg assets, and nothing else was changed, that gives us the top of the range, which is right at 39 million. So that range is kind of what you would expect if this had gone through litigation, because it's very unlikely that all of staff's recommendations would have been adopted by the commission. So that range represents, maybe accepting 3 or 4 of our recommendations, you would fall somewhere in that range.
So, Mr. Molden, is this, how as a staff member that you evaluate litigation risk? Is you come up with scenarios like this when you are trying to decide what to negotiate for and whether or not to settle?
I would say litigation risk is usually not, at the forefront of my mind when approaching a settlement. Really what I, especially with this case, was relying on what we had originally proposed and kind of that big picture number. Because I really do feel like we did our due diligence to get there to that number. And ultimately we felt that number was just and reasonable. And so that's kind of the forefront of what's in my mind when approaching settlement discussions.
I also had a couple of questions later on in that page. You're continuing that answer. And at line 16, you say, granting the company the flexibility to distribute the agreed upon increase in revenue where it sees fit as advantageous for both customers and the company. That's your testimony?
Yes, ma'am.
How is that advantageous for gas companies' customers?
Ideally, you know, allowing the company to allocate that $30 million where they see fit. They would allocate it to projects that they feel that they need to complete to continue to provide safe and reliable service to their customers, and for things such as like the CIS upgrade, which will give customers, I think will provide efficiencies and benefit customers, things like projects of that nature. So it's going to be like I viewed it as a optimization for the problem for the company. They have to optimize where that money goes, and ideally, if they, I guess, allocate it in the company's and the customer's best interest, they know where that money should go best as far as yeah, I mean, I think the company knows their operations better than anyone. So
Sir, what had a question on page 15 of your testimony? You're answering the question posed at line 1. Why did staff agree to the regulatory assets and liability provision in the stipulation? And you begin your answer at line 2. Staff believes the aggregate result of the stipulation is net positive despite the rate making treatment gas company put forth in stipulation exhibit 1 being different from what staff proposed. What specifically are you referring to in the stipulation exhibit 1?
I believe it was the fact that they had all the reg assets and rate base, as well as the I believe a 2-year amortization for all of them. And kind of specifically them being in rate base, because I believe our direct position was to have none of them in rate base, besides maybe the 2 that were previously there from the last case. But again, I mean, it may not be how the company actually accounts for the reg assets.
Right, but and I'm just I just wanted a specific reference. If there was any specific page or line or whatever in stipulation exhibit 1, or are you referring to the whole 19 pages?
I don't have it in front of me, but it would be the probably
Here you go.
specific. Okay, thank you. So it's probably going to be
Okay, so the first part is cost of service reconciliation.
yeah,
Do, 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 do.
regulatory assets and liabilities. I think you passed it.
Did I?
Yeah. So it'd be the rate base portion of reg assets, which should be a bit up. I think, yeah, right here. So this, yeah, lines 99 through 104.
Sit. Okay. So that's what you're referring to in your testimony here.
Yes, and I should have cited that. That's my apologies.
Let's see, 99. 4. Step 1. Page 3. Thank you. Yeah. And on the next page, you refer to stipulation exhibit 1 again twice, once on line 1 and once on line 6. Are those the same references?
Yeah,
Let me.
yeah.
Okay.
And also, I believe it would be also in the expense for the amortization. That's where the, because I plugged in how they have them treated into our model, and it resulted in a $281,000 increase. So it would be the regulatory assets and rate base, which we just looked at, and also their corresponding amortization in operations and maintenance, which assuming is 2 years across the board for all of them. Well, not assuming, it is 2 years.
Okay. So something else in STIP exhibit 1.
Yeah, so it would be in operations and maintenance and
Go down. Nope.
yeah, towards the bottom.
Back the other way.
Again, my apologies. I should have cited these.
There we go. Fuel. Transmission.
Should be towards the bottom of these
Oh.
expenses.
Customer related.
No. Yeah, I think a little bit more down.
There. No, not the A and G. You want me to keep going?
Yes. Okay. The other allowable expenses.
Okay.
393 through pretty much all the ones that match the reg assets and rate base, basically. So it'd be the COVID reg asset amortization, the rate case expenses for previous and current, and the legal liability, IMP regulatory asset.
So 393, 394, and 396.
390, not 396, 399 and 400, but the other two were correct.
Okay. 399, 400. Okay. Page 9. Okay. I think the last question, no, last series of questions that I have for you, Mr. Malden, is on page 20 of your testimony.
And that was the stipulation testimony.
Yes, sir.
Okay.
On page 20 of your testimony, at line 15,
I don't think our pages match up, but
They might not. I can't tell you what I printed from, if I printed from the Word or the Adobe. But essentially my my page 20 at line 15 says, what is staff's position on tolling?
okay, yes.
And I believe that the stipulation includes paragraph 38, which says the signatories agree to toll the running of the application suspension period for a period of time beginning with the commencement of the parties' settlement negotiations and ending with final commission action on the stipulation. The signatories agree that on the date settlement negotiations commenced was February 23rd. You're referring to that particular provision in this testimony?
Yes, and I also wanted to answer that from the order outlining what the parties had to address in their stipulation testimony.
Okay. But the signatories agreed to this provision, correct?
Yes.
So why did staff find it necessary to include this in their testimony?
Really, for me, I just wanted to check all the boxes to make sure I answered everything in that order. And I would, preface the answer by saying, I'm by no means a lawyer or a legal expert. So yeah, I mean, really, it was to answer the procedural order question and make sure all the boxes were checked.
So am I to, if I understand your testimony, is the takeaway that staff is not supportive of potential commission tolling of the application?
I don't know that that's the case. I mean, I think, as long as it's legally allowable, then staff is not opposed to it. I think.
Well, if you didn't think, I'm sorry, sir, go ahead.
Oh, I think I was finished.
If you don't think it's legally allowable, then why did you sign the stipulation?
That is a good question. Well, I mean, I would say that, our position is that we defer to the stipulation, and we agree to that in full. So, yeah, I guess this answer might kind of conflict with that, though.
Okay. Mr. Molden, I believe that that's all the questions I have for you. Thank you for your time, sir.
No
Mr.
problem.
Borman, any questions for Mr. Molden?
No, I do not have any redirect for Mr. Mullen.
Any questions from any of the parties for Mr. Molden? No. Hearing no questions. Thank you, sir. You're excused.
No problem. Thank you.
I think now might be an appropriate time for us to have our morning break. It's 20 after 10. Let's have a recess until 10:30, and we'll come back with your next witness, Mr. Borman.
Thank you.
Thank you. Remember, we are on the YouTube.
Did you mean half an hour? Or, oh, I guess you did. That's 10 minutes. Never mind. I'm losing track of the time.
How are we doing, Melissa?
I'm back.
You're back. All right.
Yes.
Great. Okay, well, I think we're back from our recess. So I think we can begin, go ahead with our presentation. Mr. Borman, I see Mr. Black is back. Hello there.
Mr.
Hello.
Black is back, and with your permission, I would relinquish my chair to him.
All right, sir. Thank you very much.
Thank you for your indulgence, ma'am.
Appreciate it. Mr. Black, you have another witness. It looks like Mr. Zigich.
Yes, indeed. Can he be sworn?
He can. Melissa, am I pronouncing his name correctly? I am. Hello there, Mr. Zigich.
Hello, Madam Hearing Officer.
If you would swear the witness, Melissa, please.
Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Go ahead, Mr. Black.
Thank you, Madam Hearing Examiner. Good morning, Mr. Zigich. How are you?
Just fine, Mr. Black. Thank you.
Okay. And you've been sworn. You understand that means you're telling the truth here.
Yes.
Okay. For the record, please state your name and your position with the Public Regulation Commission.
My name is Darren Keith Zigich. I'm an engineer here at the New Mexico Public Regulation Commission.
I have provided to you a document that has been previously marked as staff exhibit number 2. Do you have that document?
I do.
Could you please identify that document?
It's my prepared direct testimony for this case with exhibits.
Okay, did you prepare those exhibits
Yes.
under your direction and control?
Yes.
And are those exhibits true and accurate?
Yes.
Okay, now, was your entire testimony drafted by you or under your supervision?
Yes, it was.
Okay, thank you. Do you have any corrections to your testimony, sir?
No, I don't.
Thank you. Now, if I were to ask you the questions today that are posed in that testimony, would you give the same answers today verbally under oath?
Yes.
Thank you. Is that testimony true and accurate to the best of your knowledge and belief?
Yes, it is.
Okay. Madam Hearing Examiner, I move what has been marked as Staff Exhibit 2 into the record.
Thank you, Mr. Black. Any objection to what's been identified as Staff Exhibit 2? Mr. Zigich, direct testimony filed in this case as affirmed by him here today. Hearing no objection, Staff Exhibit 2 is admitted. Mr. Black?
Thank you, Your Honor. Mr. Zigich, for the record, I have presented to you a document identified as Staff Exhibit number 10. Do you have that document?
I do, yes.
Could you please identify that document, please?
That is my testimony in support of the uncontested stipulation in this case.
Thank you. And are there any exhibits to that testimony?
No, there are not.
Okay. Was this stipulation support testimony drafted by you or under your supervision?
Yes, it was.
Okay. Do you have any corrections to that testimony?
No, I don't.
Now, if I were to ask you the same questions that are posed in that testimony, would your answers be the same today, verbally under oath?
Yes, they would.
Is that testimony true and accurate to the best of your knowledge and belief?
Yes.
Thank you. Madam Hearing Examiner, I move what has been marked as staff exhibit number 10 into the record.
Thank you. Any objection to what's been identified as staff exhibit number 10, Mr. Ziggich's testimony in support of the stipulation as affirmed by him here today? Hearing no objection, staff exhibit 10 is admitted. Mr. Black?
Thank you, Madam Hearing Examiner. I tender Mr. Zigich, staff witness, for examination by the hearing examiner or any commissioners. I don't see any, but they may pop up.
Thank you, Mr. Black. I think it's open meeting day this morning. So I think there's a competing procedure. Mr. Zigich, welcome.
Good morning, Madam Hearing Officer.
I don't believe that I've had you testify yet in a case.
No, this is actually my second verbal testimony. Me and Mr. Borman had a little go at it a couple of weeks ago, so fairly new to the game.
So you're relatively new with the commission here, is that correct?
Correct, 6 months.
But according to your testimony, you are a professional engineer, licensed here and in Minnesota and Idaho and California.
Correct.
So I take it from that you indicate that you have 27 years of continuing education requirement, and you've been in the business for over 35 years. Is that correct?
Yes. The businesses have changed. That's
Well, yeah, I wish we had time to talk about your experiences as a navigation and control engineer with the manned space program, because as a daughter of a public school teacher, I was raised to love NASA and rocks. So I kind of like to find out about those things, but perhaps some other time in a less formal setting.
Yes.
You've indicated in your direct testimony, Mr. Zigich, that your assignment in this case included review of capital investments and depreciation, the greenhouse gas emissions topic, assist other staff with cash as working capital and allowance for funds used during construction, or as we refer to it, AFUDC, and other capital expenses associated with the IT software projects. Is that correct?
Yes.
And in reviewing all those items, you indicate in your direct testimony that there were some of the projects that you had some concerns or questions about, correct?
Correct.
And the first of those being on page 5 of your testimony, the sewer camera inspection project. Correct?
Yes.
And I don't think you're questioning whether or not those types of inspections should be done, are you, Mr. Zigich?
No, it's really me. Some of my ignorance here is just trying to learn what bucket some of these costs go into. And when I see things like this going into rate base or the plant capital, it gave me pause, I guess.
And that's what I thought that you were potentially questioning, was whether or not the appropriate cost allocation was being made for those particular and I forget what the technical term was when a cross bore.
Yeah, so I think, Mr. Bullard discussed this with you earlier about how years ago, they just kind of blindly bore these, do a horizontal bore, kind of like what they're going to do with this bridge project where the bridge is being rebuilt and they're going under the river. They do that similar things in neighborhoods and elsewhere where you can't really easily trench, so you horizontally bore, and periodically these bores, again, intersected existing sewer lines in certain communities. And so they're going around, and they've been doing this for a number of years. I mean, the data goes back a number of years. So the 12.9 million that was talked about in Mr. Molden's testimony, that if you go back further, it's over 18 million. And so there's quite a bit of dollars there, and it's all being put in as capital. It's essentially like adding $18 million of new pipe to the system, because it's all getting counted as capital. And this piping that they're investigating has 60, 70, 80-year lifespans. So you're basically deferring those costs over many, many years, and the company is getting a rate of return on that. So it just kind of struck me as, something that was somewhat problematic. And then in this case, where these things are, maybe not egregious, but they're a construction error. And, my last job, every once in a while at Energy and Minerals, we would sit on the committee for capital outlay for higher education. And when schools would come in and say, we need a new roof, we need 250,000 from the capital outlay for a new roof, the first thing that committee chairman would say, well, you asked for that 10 years ago. Where's your bond from, or where's your warranty from the construction company that put your roof on? Why is it leaking in 10 years and you're coming back to us for more money? So it just kind of, those two things kind of came together as, why aren't they going after the contractor that made the error in the first place? And I think Mr. Bullard rightfully said that some of these errors were made years ago, and those contractors are long gone. So there's no way to recover that. But I was just kind of, are we sure that none of these are recoverable from the contractor? And that was kind of the point there.
And I think it was a good point, and that's why I asked Mr. Bullard about it. And so were your concerns assuaged by information that you got subsequent to the filing of your testimony, including Mr. Bullard's testimony this week on that topic?
Yeah, I mean, the other thing that stuck out is, they've only found 8 of these incidences in all of the time that they've been investigating these things. So that, again, there's a lot of this work, a lot of the cost doesn't effectuate any kind of repair or replacement of the pipe. So there's no capital expenditure associated with these upfront costs of doing the camera inspections. And so then seeing that low number, it kind of goes back to, well, is this really truly a capital expenditure, or is it more of an O&M, preventative maintenance type of thing, that doesn't really fall under a capital expense, and that's where I was kind of getting. But talking with our finance folks and stuff, it's kind of a balance of, if you put it into the rate base and depreciate it over 60 years, the effect of those costs is, it's kicked down the road effectively. And whereas if you put that whole $12 million in the rates today, that's a pretty big jump in the cost of service. So, I've got to balance all of that with the I don't know, ick factor or whatever of having it called capital when it's not really capital pipe in the ground. So. And it seems like that's been the practice for many, many years.
So it's a learning experience that you're going to keep your eye on.
Correct.
You also took issue with, and I'm on page 8 of your testimony, with the question posed at lines 15 and 16, referencing the Artesia 6-inch replacement of pipeline issue, didn't you?
Yes, I did.
And you probably heard me, because again, this concern of staff's was my concern also. And did you hear me asking about him? Or asking
Yes.
Mr. Bullard, I guess I should identify for the record, there were some pipes that were being replaced, and you had asked in Discovery some pressure questions, and you got an answer that you were trying to figure out exactly what gas company was referencing. Did the answers that Mr. Bullard gave about the specifics of the system and what they were intending to do, did that assuage your concern with regard to this issue?
Yeah, partially. I mean, I think he further explained what they're doing and how they intend to operate it. I really took exception just with his response to the Discovery, the word should. It's not very definitive. Right. And I know nothing is absolute, and especially in the engineering world, it's hard to ascertain miles of underground pipeline and make sure that it's all going to work. But it sounded like he does have some room to play with, that this improvement of that one section of pipe will not be for naught if the other section doesn't fully get up to the 720 PSI test pressure. He's got some room to maneuver there. And eventually they could replace that other section. It's just, why do one if you're not sure the other can even handle it? Because they all have to work together. You can't pressurize that one section of pipe without pressurizing the other section. And if you're not going to touch the other section, are you sure it's adequate? And I think they're as sure as they possibly can be at this point. It was just again raising a question of, are they piecemealing the project, or do they need to do the entire line? And is there some savings by just going all in and doing the entire project?
And if you're listening, you probably heard me observe to Mr. Bullard, that, you know, I was not aware of the rest of the response that gas company had given you, but if it did not include the explanation that he gave me, that they might want to be, you know, a little more comprehensive in their answer to staff's interrogatory to assist you. Did you?
Yeah, I mean, I understand their side of it too. Sometimes our questions are not as clear as or comprehensive as they could be either. So I think we get this. I have to say, gas company is, you know, my limited experience at gas company is a bit better at answering questions than maybe some other utilities.
Well,
But that's a very short.
we'll put a pin in that one, Mr. Zigich, and let you get a few more utility experience on that. But that's good to hear. I think that sort of carries through with what some of the interveners have indicated. Communication, I think, you know, between the staff and the regulated utility is very important. Moving on with your testimony, the greenhouse gas emission review, you set forth in your testimony that you do believe that they're in compliance, but you did highlight a couple of instances where you think improvement could be made. Did you get any feedback you're referencing on page 11 the 2021 stipulation, and you indicated at line 15 and 16 of that page, gas company anticipates the information may be available for external review in first quarter of 2021. Do you have any update on whether or not you got that information, or?
No, but I think Mr. Wiesen did say that they are in testimony this week, said that they are implementing that now. I have not, they may have sent that in to the commission and I just didn't see it. It certainly wasn't sent to my attention, or if it was sent in, I wasn't on the email list, the service list. But I think Mr. Wiesen said that they are implementing that program now.
Okay. And the last part of your testimony, you seem to take issue with gas companies' efforts or lack of same with renewable natural gas.
Yeah. Again, some of this comes from my days at the state energy office over at Energy and Minerals. You know, the state has gone to great lengths to provide tax credits for biomass. There's a biomass tax credit at the state level, and a lot of that is for manure management in eastern New Mexico, and it's to help with transportation costs of that waste to digesters and in renewable natural gas. And the gas company is certainly taking, you know, transporting that Kolb bio project on the discounted transportation service list is one of the biodigesters in eastern New Mexico that puts their gas on that pipeline. And it's a common thing for both the gas company and for the electric utilities, because under the Energy Transition Act, renewable natural gas is considered a zero carbon resource, depending on how it's used. And so I think we need to seriously be looking at that, because when I see other cases, especially like on the electric utility side of things, where a little bit of energy storage is coming in at numbers that are in excess of the gas company's entire plant in service, it shows me that we need storage and production of that resource, potentially moving forward, that it would benefit both the gas company and the electric utilities in the area. And there should be some common goal there to move that along.
Does the stipulation address that particular topic?
It does not, no. That was a little more commentary. It's really comparing it to the hydrogen part of that stipulation, because renewable natural gas is just like regular natural gas, fossil natural gas, in its ability to move through the pipeline and being able to use it for customers and everything else. Hydrogen is a much higher bar, A, to produce it, and B, to transport it. Being from I spent a number of summers waiting around for hydrogen leaks on the space shuttle to get fixed so that we could keep doing our job. So hydrogen's a very, very troublesome. It's a small molecule. It doesn't like to be contained, and just leave it at that. But if they're willing to do work with hydrogen, it'd be nice to see a little more action on the renewable natural gas side of things.
So, sort of as I indicated to staff witness Malden in one of his suggestions that wasn't covered by the stipulation, this is something at this point, at least you pointed out to gas company, it's more aspirational than in terms of going forward than directly relating to what was stipulated. Is that fair characterization?
Yeah, correct. Yeah, and this is on the old stipulation from the previous case, correct?
Right.
Yeah.
But it sounds like it's an issue that staff's going to keep an eye on going forward.
Yes.
Okay. And just so I don't forget, you looked at their transportation rates or no? Is that something I'm going to want to talk with?
I looked at for the stipulation,
well,
they're
or is that Miss Labor Tercero that I want to ask about specific rate information?
Oh, yeah, that would probably be. Yeah, I just looked at the discounted rate.
So
Yeah,
you did look at
that's
the
it.
discounted rate. Okay. Well,
Yeah.
did you have a chance to look at the let's see. There we go. Did you have a chance to look at that yesterday? The gas company response to the 5th bench request
Yes.
on the discounted transportation rate?
Yes, I have.
Okay. And then
And I concur with Mr. Bullard there on that price per therm.
Okay.
That matches up with their July 5th. I pulled that July 5th filing.
Okay. And then, oh, I don't see it in the filing. No, that's the 4th. Okay, let me see if I put it on my flash drive. Because they filed another one, they filed the 7th, which I admitted this morning, which was called Explain How Non-Discounted Transportation Customers Are Charged versus How Discounted Transportations Are Charged. Verify the charges for the transportation customers. Did you look at that one?
Briefly, yeah. I've got it up.
Here, I've got it. Just had to find it. Mr. Domi, Mr. Haverly, you might want to check to see where that is. I don't show it in our, I was looking at our e-docket. Okay, so I have to share it though, don't I? Oh no, I'm sharing it. Okay, so did you have an opportunity to look at this, Mr. Zigich?
I'm not seeing.
Madam
the
Hearing
screen,
Examiner, we have the lovely alligator crocodile.
Fly, porcupine, quill.
Fly, oh, the porcupine quill, yes.
Yeah, felt sorry for the little
Yeah.
fella. Wasn't gonna try to extract that though. Because it had friends, bigger friends that were around. Okay.
Excellent, thank you.
Thank you. Okay, so here this is. So you've had a chance to look at this and
Yeah, just briefly, I more was confirming that table was the same that is in the stipulation.
okay. And is it?
Yes.
You don't have any reason to believe that the rate that the rate information isn't correct, do you?
No, I really can't comment on that. You'd have to go through each one, I guess. And
Okay.
Madam Hearing Examiner, this is Brian Haverly.
Mr. Haverly.
I just looked at the e-docket. Our 7th response is there, but it has a COS in front of it, like as if it was labeled as a certificate of service, but the whole document is there when you click on that in the e-docket.
Okay, I'll check that out.
Okay.
Okay, let's come out of that. Let's do that. Okay. So in your stipulation testimony, Mr. Zigich, at page 4, you're answering the question on line 6. Are those depreciation and amortization rates in stipulation exhibit number 1 reasonable? And you begin your answer at line 8 saying you're only testifying on the depreciation rates that you indicate that you reviewed, and that you find that the rates reflected in the stipulation are fair, just, and reasonable. That's your testimony, sir?
Yes.
And these are not new depreciation rates for this case, correct?
Well, that was a little surprising that Ms. Crane, I think, said that yesterday. And in fact, this case does have a transition from old rates to new rates because the gas company did file a new depreciation rate study on June 30th of last year. And so they are proposing a change, and you can see that in their cost of service or cost of plant to their depreciation. It changes, I believe, at the end of September of 2023. You can see the step change in the depreciation rates. So they have modified their depreciation according to the new depreciation study.
Does the stipulation specifically include a request to approve new depreciation rates?
Well, it's proposing to use the depreciation rates outlined in the cost of service model, which are based on the 2023. Well, it's a depreciation rate study at December 31st, 2022, but it was submitted in June of 2023. Those depreciation rates are based on that study going forward.
I didn't see a request in the stipulation regarding that the commission approve any new depreciation rates. Did you, Mr. Zigich?
Let's see. Let me get back to my. Well, exhibit 1. That's what I highlight. Let me see. I'm sorry.
You talking about stipulation exhibit 1?
Yeah.
What page are you looking
Yeah.
at?
It's page 17 of 19. And it continues on to page 18 and 19. So the last 3 pages of exhibit 1. It shows the depreciation rates as they were and as they are moving forward. And, and there's some significant changes. A lot of them are smaller. If you go to that next page on page 18, you'll see the rate there jump on line 64, 65 jumps from 5% to 15%. Now some of that is associated with their cathodic protection systems, where the anode is in the ground, it just deteriorates. So the lifespan of some of these things is 5 years or less. So it makes sense that the depreciation would be that high. So that they did this new study and reevaluated some of their operating experience and engineering experience, and to come up with some of these new lifespans. And then they also looked at the cost of decommissioning or if they can just leave it in place, then there is no decommissioning cost. So, so some of those things changed and effectuated a change in those annual depreciation rates. And you can see that throughout their cost of service model, that the depreciation changes at a certain time period.
Okay. But I think the next part of your testimony has to do with the discounted transportation rates. I think we just looked at those two bench requests. Responses. Not really sure, Mr. Zigich, you can tell me. In the hierarchy of the engineers and in the allocation of responsibility, are you the one that would be notified about what process gas company uses to be in compliance with Rule 660?
Well, not me personally. Since I'm fairly new here, there was another engineer that was working more closely on gas company cases. And then, of course, the division director usually gets copies of a lot of these, these other documents that come in that aren't linked to a certain case.
Did you have the opportunity to find out if there is an internal process that the utility division uses with regard to these 660 filings?
No, I know that you're talking about the discounted transportation rates.
The
When those are
actual
filed.
filings?
Yeah, I did talk to an engineer that's been around for a while, and he said, yes, they do review those. And but I didn't get into the details of each one. I basically made the assumption that they were submitted, they were approved, and therefore, as long as there's no changes to what's already been accepted, then the stay put was acceptable.
But in this process, where do you think in the process they get approved? What do you mean by that?
Well, I don't know exactly how those get approved or not approved. I know other advice notice type things, under utility, the 440s, advice notices, those, either get, they basically within 30 days or so of submittal, they just become accepted unless stopped by staff otherwise, or if they notify the commission to suspend those. So I don't know in each case if it was actually reviewed and approved by staff, or if it was just one of these cases where it was never opposed, and therefore it just became.
Basically, under what we went over at the beginning part of our hearing, Mr. Zigich, this is Rule 660. I believe
Yeah,
10, 8, 10 F8. That, as you can see, says basically that they file these rates within 5 days of the agreement. And this says the new rate becomes effective as of the initial transportation service date. The rate shall be deemed authorized by the commission and not subject to these other notice rules, blah, blah, blah. Okay. So basically, if you look at one of these things, it's the company perspective that there's there's not really an approval process. I believe the language was, and these are deemed effective by operation of law, is what my brain tells me that this process is. Do you understand the difference?
yeah. I see what you're saying too there. This transportation thing just kind of creeped in at the last minute because it was part of the stipulation, and yeah, I probably dropped the ball on looking deeper into this. There was no change from what was, and so I didn't feel it was. I didn't want to get into the business of second guessing previous decisions, I guess, and
Okay,
so
very well. I guess the last part of that I was going to ask you about your testimony had to do with the line extension policy.
yes.
That seems to be an issue. I think that that was a WRA. I believe Ms. Farnsworth testimony. That was a WRA issue. Do you know if that's correct?
That's my understanding, yes.
And are you aware of any review or any investigation that staff has conducted? If I recall the testimony correctly, I think it's been in place since at least 2015. So has staff done any review or investigation on the line extension rule since it went into effect?
No, and it was revised in August of 2015. So I don't know how far back it goes before that. But clearly there's some questions about some fairness, and since it hasn't been revised since 2015, I don't know if anything has been turned up on that since then, or looked into that since that time.
And that's going to be something that, since there was an agreement and we don't know what the process is going to be yet, but there was some type of agreement in the stipulation to look at this, wasn't there?
Yes.
Is that going to be you?
I don't know, but I think I'll be on the short list.
Okay. Very, very, very well. Thank you, sir. That's all the questions that I had for you. Mr. Black, any any questions for Mr. Zigich?
No, Your Honor, I have no questions.
Any questions from any of the parties for Mr. Zigich? Hearing none. Thank you, sir. You're excused.
Thank you.
I just want to have gas company clarify, Mr. Haverly, this issue about the depreciation rates and whether that, that there was such a request made in your application, and if there was, how does the stipulation deal with it or not? Do you know?
I need to look at that, Madam Hearing Examiner.
Okay.
But I'll be able to, I think, get back to you today.
Okay, well, can you look at that over the luncheon hour?
Yes, ma'am.
Okay, very well. Okay, I think we have another witness. I see that Mr. Tupler is there. Let me admit him. Good morning, sir. Gonna unmute.
Exactly. Good morning.
There
Madam
you
Hearing
go.
Examiner.
You want to formally call your witness, Mr. Black?
He's on mute.
You have to unmute too.
It's funny how that works.
I know it is, isn't it?
Thank you. My apologies. Good morning, Mr. Tupler. Can he be sworn, please?
Yep. Melissa, would you please swear the witness?
Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Good morning again, Mark Tupler. How are you?
Hi, very well. Thank you.
Okay. For the record, please state your name and position with the Public Regulation Commission.
Yes, sure. My name is Mark Tupler. I am employed by the New Mexico PRC as a senior economist in the utility division.
Thank you. I have provided to you what is numbered staff exhibit number 4. Do you have that document?
Yes, sir, I do.
Please identify that document.
It is the prepared direct testimony that I submitted in this case on February 21, 2024.
Thank you. Are there any exhibits attached to that testimony?
Yes, there are a total of 3 exhibits attached.
Okay, and were those exhibits prepared by you or under your direct control?
Yes, sir, they were.
Okay, and are those exhibits to that testimony accurate?
Yes, they are.
All right, then. Now, was the full testimony we're discussing here drafted by you or under your supervision?
Yes, they were.
All right, then. Do you have any corrections to that testimony?
No corrections.
Now, if I were to ask you the same questions that are posing that testimony today, would you give the same answers today orally under oath?
Yes, I would.
Thank you. Is your testimony true and accurate to the best of your knowledge and belief?
Yes, sir.
Thank you. Madam Hearing Examiner, I offer into the record staff what has been numbered as Staff Exhibit 4.
Any objection to what's been identified as staff exhibit number 4, the pre-filed direct testimony of Mr. Tupler as affirmed by him here today? Hearing no objection, staff exhibit 4 is admitted. Mr. Black?
Thank you, Your Honor. Mr. Tupler, I have previously marked and provided to you what is which has been provided to the parties as staff exhibit number 9. Do you have that?
Yes, sir, I do.
Okay, please identify that document.
Sure. It is my testimony in support of the uncontested stipulation in this case, dated March 13, 2024.
And there are no exhibits to that testimony, are there?
There are none.
Okay. Was this stipulation support testimony drafted by you?
Yes.
Okay. Do you have any corrections to that testimony?
No corrections.
All right, then. If I were to ask you the same questions that are posed in that testimony, would your answers be the same today verbally under oath?
Yes, they would.
Is that testimony true and accurate to the best of your knowledge and belief?
Yes, sir.
Thank you. Madam Hearing Examiner, I move what has been marked as Staff Exhibit 9 into the record.
Any objection to what's been identified as Staff Exhibit 9? Mr. Tupler's testimony in support of the stipulation as verified by him here today. Hearing no objection, Staff Exhibit 9 is admitted. Mr. Black?
Thank you, Your Honor. I now tender Mr. Tupler for questioning by the hearing examiner.
Thank you. Hello there again, Mr. Tupler.
Yes, ma'am.
How are you doing today?
Very well, thank you.
Good. Mr. Tupler, you, for the staff, are the return on equity and capital structure witness.
Yes, ma'am.
And in conjunction with your staff teammates, and I think I've already talked with Mr. Malden this morning. Staff recommended an amount less than gas company requested in the revenue deficiency category. And part of that included a return on equity that was less than they requested as recommended by you, correct?
Yes, ma'am.
And you recommended a 9.85% return on equity, correct?
Yes, that is correct.
And you also agreed with the company to change the capital structure from a 52-48 to a 53-47. Is that correct?
Yes, in my original testimony or my direct testimony, that was the case, yes.
And excuse me. In your direct testimony, you indicated, I believe, on page 22, the questions posed at line 16, what is staff's basis for the recommended capital structure? And you begin your answer on line 17 through 19, and you say staff's basis for the capital structure recommendation is the actual existing capital structure. And then you have in parenthesis status quo as it appears adequately capitalized and at no unnecessary cost to customers. That's your testimony, sir?
Yes, ma'am.
Well, I'm just a bit quizzical about the actual existing capital structure, and just would like for you to explain to me, put that in context with the fact that this is an imputed capital structure that takes the goodwill out of it, correct?
Yes, ma'am.
So how are you defining actual then?
Well, I did hear the description over the past few days of the different capital structure numbers, if we can call it that. I think the actual that I'm referring to, I know the actual that I'm referring to in my testimony is the regulated results, if I can call it that, within a percentage or two.
Doesn't the percentage or two in changing it from what has been existing in the past three rate cases of the 5248 results in a dollar amount, doesn't it, Mr. Tupler?
Yes, ma'am.
And do you know what the difference is between a 52 and a 53% return on equity?
You know, I've seen the number previously, but I can't put an exact number to it. But it's got to be a material number. These are big numbers to begin with.
Okay, so whether the company or the commission were to authorize the 53 or the 52 makes a difference, right?
It does make a difference, yes.
Okay. So I just have, just so we have the numbers, I put on the screen the last three that have been decided in this one, the rate case comparisons. And initially in this case, gas company asked for a 10.5 return on equity, right?
Yes, ma'am.
And when you look at the, did you review the other party's testimony?
Yes, I did.
Okay, I'm sorry, I was getting feedback from somebody.
Yes. I think that's your.
Somebody is not muted. Okay. Very well. So I lost my train of thought there for a second. We're talking about cap structure. The consistently, at least in the last three rate cases, the company has settled on a 5248, correct?
Yes, ma'am.
And consistently in the last three and in this one, the company has settled for a return on equity that is lower. They've settled in the 9s when they have come in and requested in the 10s in every case, correct?
That is correct.
Do you consider that information when you are putting together your analysis of what you think is an appropriate return on equity?
Let me be sure of the question. Do I consider the company's application numbers?
Do you consider, just in looking at the pattern of coming in, asking in the 10s for an ROE and settling for 9s?
I see that. I don't think it runs into my evaluation, though. Each of the parties has a different methodology and maybe even strategy for the numbers that are submitted. I like to say that the staff analysis and the staff methodology is done almost in a vacuum based on market data, unskewed information, unskewed data, and solid methodology approaches. The number that comes out the other end is not something that I have any bias towards. until the number is produced. Then I can compare it to everybody else's one way or another just to get a gauge of how close my staff number is.
Well, it is very interesting, the recommendations, because right under, in looking at the actual recommendations, staff came in right under gas companies' ROE recommendation at 9.85, correct?
Yes, ma'am.
And then the rest of the ROE recommendations were 9.55, 9.5, slash, the one was or 9.4, 9.375, and a range between 8.5 and 9, correct?
Yes, ma'am.
Did the lower recommendations, using the same types of methodologies, specifically the DCF, did that cause you any concern that they were lower, and some of them significantly lower than what you had recommended?
It certainly does.
But it didn't have necessarily the effect to make you file any supplemental testimony to change what you did?
No, not at all. In fact, I would tell you, in my review, I go back and look at the data and the variables that are used in the calculation of the DCF, and I can identify where the differences are. It's a very simple formula, but the information and the variables that go into it are market driven. They're averaged, at least on the stock price, they are averaged over a 30-day end of year period, which gives you a nice broad average of the stock's price, of a stock's price in my representative peer group. The dividend itself is not variable, it's not arguable. The one element that is the biggest variable is the projected growth rates. And those are earnings growth rates. Because at the end of the day, the only thing that matters to the publicly traded peer group stocks is earnings. I use 3 different market standard and market accepted research analysts that produce growth rates. And I take a very strong average of those growth rates. I can sensitize them if need be to try to understand why there might be outliers in a particular growth rate projection, I guess is what it would be, to see if it fits into the group. I think the growth rate that I used in the staff methodology is as sound as any available.
Part of the other variability in the DCF analysis has to do with the peer group that's selected.
Yes, ma'am.
Did you have any concern? Because I've heard this week that the shrinking number of gas companies, did that give you any concern, Mr. Tupler?
Yes, it does, significantly, I would say. Because of the consolidation, I think I heard one of the witnesses yesterday describe over a bit of history, the consolidation of that particular segment of the market, and it is, I would agree with that. However, in an analysis like this, in establishing a peer group, or what we've termed otherwise a proxy group, has to be relevant peers. Otherwise, it's not comparing apples to apples. In fact, in some of the peer groups that I've reviewed, it's not even close to apples to apples. It's not even apples to pears. It could be technically apples to bananas. I would rather have one very comparable like peer than 50 that are unlike. I wouldn't call them peers, but unlike companies. You cannot compare a $3 billion company to a $30 billion company or a $300 billion company. They don't compare.
So then it sounds like you're in agreement with the criticism of one of Mr. Deacenda's analysis that included non-utility companies and in his other proxy group.
Yes, ma'am. I see the exercise of it, but I couldn't support it because in my history, in my investment past, the risks, the operations, and there's other factors as well between regulated companies and non-regulated companies is too great, too vast of a difference to be considered a peer. Peer has a definition. Proxy has a definition. And I can't, and different conditions as well. That's the big part, is the regulatory impact, I think, is what separates a regulated utility from, say, an S&P 500 company, whatever that might be. There's too great of a distance between the two in very many variables. They're not peers.
And if I recall correctly, Dr. Woolrich, in his proxy review, included an electric company. Do you recall that?
I believe I heard something like that as well, yes.
And do you have an opinion on whether or not that would be inappropriate? Did you include any electric companies?
I don't believe.
Well, let me just clarify. Regulated electric companies in your analysis?
No, ma'am, I don't believe there's any strict electric companies, though there may be a couple that have both gas and electric distribution businesses or segments, is what I would call them. It always causes me concern, though, when the makeup or the structure of the company, the revenues of the company come from different business lines. I know there's a difference. I just haven't dived in deep enough to understand what those nuances might be. I think they're close. I think they may represent a more significant peer group or peer company is the way I would phrase it. I don't know how big of a difference they would have, though. I think they're closer to a peer than, say, a manufacturing company. Miles difference there.
I also wanted to ask you, Mr. Tupler, if I know in addition to using DCF, you also did the CAPM analysis?
Yes, ma'am.
And you know that the commission primarily in the past has relied upon the DCF? Is that
Yes, ma'am.
correct?
Yes, ma'am.
And so, you know, I'm hearing from the other ROE witnesses, you know, I ask whether or not, just for some information about what other commissions were doing and whether or not, you know, that they would recommend that the commission branch out or utilize something other than a DCF. So I'd like to know your opinion on that, sir.
Yes, ma'am. I'm very clear on this. position, I would say the DCF is the only approach that I would suggest as well. It is a function of the earnings over an indefinite period, which is basically, what a going concern has is an infinite time frame, basically, brought back to a current value as of today. The DCF truly represents the value of a company, and thus, as you solve for the ROE as well. The other methods, and if I'm not mistaken, the DCF might be also recommended by FERC somehow, or utilized by FERC as a preferred method as well. I know more particularly that some of the other methods are not preferred by FERC. The CAPM has never impressed me. I've never seen it value companies to the point where I'm satisfied with it. So I utilized the CAPM and any derivations of it as a check to see how close the DCF measures versus the other very well established methodologies. My preference would be the DCF, and that's what I recommend.
I know you indicated to me when we were looking at the past gas company, looking at all 4 cases since 2018, you indicated that their past agreements on some of these issues didn't necessarily affect your analysis. Looking at, and I can't remember who had the chart, but it could have been Dr. Borwich. He had the data on the last approved rate cases for the other utilities in New Mexico. Do you recall seeing that?
I feel like I do. I recall something, and I'm certain to recall that discussion.
Well, and I'm just wondering, so for example, I believe you were part of last year's SPS rate case, which was stipulation and was an agreed upon 9.5 ROE. Do you recall that?
It sounds about right. Subject to check.
And the P&M case, which was litigated, you were part of that?
I wasn't directly part of that, but as the ROE person, if I can call myself that, the senior economist, I do review the data that would be used in our methodology, because I believe we have a collective methodology to this. The ultimate number and the range of reasonableness, though, was done by another staff witness, and I concurred with it.
So you're familiar this was a litigated case, and the commission issued a decision in January awarding P&M a rate of return of 9.26.
Yes, ma'am.
And then we know what happened in gas company's case last time. It's a stipulated 9.375, right?
Yes, ma'am.
Okay. So do you think about not necessarily the prior gas case, but again, in your analysis, do you think about any trends or specific other utility decisions, and where the commission might be placing emphasis when you do your analysis?
Yes, ma'am, very much so. I would say part of a strong analysis is a review or an analysis of the trends of a particular case or set of cases, if I can call it that. That's one of the reasons that I utilize and we've mentioned it in the hearing here previously, the RRA averages that are produced by a very reputable source to try to balance and get an idea of where those rates are going at a national level, what they consist of. Do they have a large enough sample size as well? If I'm not mistaken, there might have been 22 cases in the last year decided, according to the Regulatory Research Associates group. They produce averages as well as highs and lows. So I take a look at those numbers. I get a feel for what a national average might look like. And then what I try to do is position the company that in the case that I'm working on, I try to position that company somewhere on that continuum. Somewhere in there around the average is where I want my number to fall, because it's reflective, again, of unskewed actual data in the market.
But, and I wanted to just follow up with you on page 29 of your testimony. You posed a question at line 9. What cost of equity estimate did staff's DCF analysis provide for? And you answer at line 10, the average calculated DCF cost of equity estimate is 10.24 unadjusted. And then at line 12, you say, what adjustment did staff come up with to the recommended ROE? And you begin your answer at line 13 that your initial range of ROE was 9.41 to 10.24. And there were adjustments that were proper to provide for additional granularity in the final recommendation. After analysis of the peer companies' recent regulatory actions and guiding court decision, it staff's position that an ROE slightly above the average of the range is proper to reflect the noted higher than average regulatory risk and recommends an ROE of 9.85%. That's your testimony, sir?
Yes, ma'am.
Why is it you believe that gas company has a higher than average regulatory risk?
Well, one of the things that I rely on is independent research analysis of their debt. I look at bond ratings in the peer group and, of course, the company, get a gauge of where they may fall within that analysis of debt. And I take it a step further. I take it a step further by understanding where the credit reviewers or the credit evaluators use of their methodology to determine their ultimate credit ratings. Regulatory risk in New Mexico is high on the list of the credit evaluators. And I believe I've seen something to the effect that up to 40% of their credit rating is regulatory risk in their methodology. The rest being financial impact, operations, market conditions. There's a number of others that these large credit evaluators utilize. Regulatory risk is what they seem to highlight. And because it's weighted so much in their final credit rating, I make an assumption that if it's highlighted by them, it's got to be highlighted by me.
But Mr. Tupler. When we look back, and I won't pull the chart up again, but we look back and we see that they've settled, the past 3 cases. And obviously they've gotten terms that they think are acceptable and reasonable. And the commission has approved those. I mean, don't you think it's reasonable to conclude that another utility who litigates every case, when you're thinking about comparing gas company to somebody like that, that really, with the way that gas company has operated, at least in the past 3 rate cases, that there's very little regulatory risk compared to someone who litigates every, fights out every issue. You don't look at it that way.
Oh, yes, ma'am. I do see it that way. What concerns me, though, is that there's no adjustment in their bond rating. That tells me that there must be other variables within their methodology that are causing the bond ratings to be, if I can call it, less than average is the term I would use.
Well, maybe some of these credit regulators just aren't giving the commission any consideration or giving them any positive recommendation for their actions with regard to this company. Don't you think that's possible?
That is definitely very possible, or it's reasonably possible. I don't know how probable it is. These rating agencies evaluate 50 plus jurisdictions. So I'm certain that they're very efficient at their process because they are accepted by the investment world, which is not only domestic, but internationally. There's something behind it that is causing, and I think there was something in my testimony, if I'm not mistaken, about where New Mexico as a state ranked in a regulatory environment against those other 50 domestic jurisdictions. And if I'm not mistaken, we were very near the bottom. And that's my concern when I try to evaluate what is causing that.
Well, it just seems like to me, I don't know what factors they use. I know what factors they say they use, Mr. Tupler, but I don't really understand how they can negatively ding the regulatory risk here when the commission, when you look at the commission having approved all 3 of their stipulations in their last gas rate cases, right?
I would agree with that.
But it doesn't seem like say that they give the commission any credit for approving these stipulations on the terms that the gas company agreed to and within the timely manner as required. And they come in every 2 years, right?
Yes, ma'am.
Although I think I got Dr. Woolrich to say, well, yeah, if we just went ahead and approved a 10.5 ROE outside of the stipulation, that, the commission might get credit for that, right?
I did hear that conversation when it came up, and I kind of smiled about it because I don't know how that would be considered by a credit rating agency. I can't form an opinion there because I don't know if that's good or bad overall.
Well, it seems like the credit rating agencies just want the commission to approve the highest ROEs possible.
Well, I don't know if that would make sense to their investors. Their investors being the credit rating agencies' clients, the investment public, if I can call it that. You got to remember that debt is a very large part of the overall investment market. In fact, it's larger than this equities market. So,
Well, and that nice segue, because that's the next question. I mean, when you look at their actual capital structure and knowing, as the testimony has been discussed earlier in the week, knowing that they have approximately 800 million in equity, and 400 of that is taken out because of the goodwill portion. And knowing that they have this parent company who can basically, if they need money, the parent company can give it to them. So why is debt a concern?
well, let me frame that question. You're asking about why is debt a concern to the gas company or to the investment
Yes.
public?
Well, no,
If-
just a gas company. I mean, if you're looking at their actual, not just gas company being a regulated utility on its own, but knowing, that they have a parent company and the parent company is situated. If the parent company wanted to, to provide resources to them, I don't see gas companies' ability to go out and borrow money to be that big of an issue. Is it?
Okay, so well, there's 2 points to that question from my perspective. I believe the bonds that the gas company issues are to the investment public, not to the parent company. In the investment public, there's of course competition for that money, for those bond proceeds, if we can call it that. So the more favorable the credit rating, as an example, the lower the cost typically of those bonds.
Right.
On the other side of that equation, you have parent company contributions that are considered equity, of course, but the parent company might have other subsidiaries that have a higher return that compete for the parent company's capital. And of course, a parent company has ways of raising capital themselves, but it's a finite resource. And when you're competing for capital, my perspective would be that if there's other alternatives, it will typically, a prudent investor would typically allocate funds to where their best return is going to be, is what I've seen in my history. So there's competition for equity dollars, and there's competition for bond proceeds, if you will. I'm trying to use the right term there, when those bonds are floated or sold to the investment public. I do not believe the bonds are held by the parent company, but I'd have to have validation of that. That's just what I feel in my head at the moment. That's why they have the bond ratings, is because they're floated to the investment public. I hope that was an answer to your question.
It was an answer to my question. Thank you, Mr. Tupler.
Yes, ma'am.
Let's talk about the stipulation. The stipulation agrees upon to maintain the the stipulation agrees to maintain the capital structure that exists being was agreed to, imputed capital structure agreed to in the last stipulation. of 5248, doesn't it?
Yes, ma'am.
And also the agreed upon return on equity is 9.375, which is a continuation of the prior two rate cases, isn't it?
Yes, ma'am.
And then the other major money dollar is the $30 million that the parties agreed to as a revenue deficiency amount, correct?
Yes, ma'am.
And you indicate on page 3 of your stipulation testimony that the 9.375 is in fact acceptable to staff, correct?
Yes, ma'am.
But yet the 9.375 is actually outside of your range, isn't it?
It is very slightly outside of my lower bound. And if I had to pick the side of my range of reasonableness for the settlement to be, I would, of course, believe that the lower end is more proper to the public interest.
Why?
Two reasons. First and foremost, if the company is comfortable with it, in the back of my mind, I feel comfortable with it. And like I mentioned, because it's on the lower range, that means lower cost ultimately.
Okay. What's the other reason?
Oh, I think I meant to divide that in half then. If the company's comfortable with it, it's comfortable to me. And since it is on the lower end of my range of reasonableness that I determined, I'd rather see it on that end than on the other end, which sounds expensive to a ratepayer.
Oh, I pulled up the wrong testimony. Just 1 second. There it is. Wanted to give you an opportunity, sir, to opine. You've seen this earlier in the week.
Yes, ma'am.
And what I'm referring to is the attachment to Mr. Sandberg's testimony, which was the Attorney General Interrogatory 1-10. And this is the chart table, or referred to as Gas Company Table AG 1-2. And it shows what they call the regulated and the allowed return on equity since 2018. And I'll just indicate for the record that this was changed in it, and I believe for all of 2023, the number is 9.2. Does that sound right to you, Mr.
Yes, ma'am. That's
Dublin?
what I recall as well.
Okay, so Did you have access to this during the case before you filed your testimony? If you remember.
I don't believe I had access to it, but I think I've seen something like this previously. So I'm comfortable with it.
Well, I'm just wondering if you had this information and whether or not it had an impact on your recommendation.
I didn't have access to the information in this format, but I would tell you further, it didn't impact my analysis because, like I mentioned earlier, I like to perform the analysis of the peer group in a vacuum without any preconceived target numbers. I like the numbers to stand on their own, to speak for themselves, and for me to put it together with a range of reasonableness and an actual recommended number.
So when is it you consider all the things you just testified to, like the ranges of what's going on nationally and that kind of information? Where does that come into play in your analysis?
It takes place after the peer group analysis.
Okay, so if I'm understanding you correctly, you have your hard data analysis, and then you consider other things.
Yes, ma'am.
Okay, so did you consider this information after you had done your hard data analysis?
No, I didn't.
Do you think it would have made a difference? I mean, you know, I've gotten some really good explanations, and I think I understand this chart. And Gas Company has actually added a third column in response to my questions. But based on the testimony, I think that I heard this week, I believe they were correct when they said to me that these are really the two columns that are comparing the apples. Do you agree with that?
Well, the apples would be the ROE. The historic ROE is what we're discussing here.
Yes,
That's
sir.
that's the apple. Okay. I don't know if that's the approach that I would take though in formulating a current period ROE.
And
Because
all I'm asking first is, do you think this is the legitimate comparison, or do you think gas companies where they added the third column that basically looked at their real equity? Which is the more helpful comparison, if any, in your mind?
I'm not sure I would utilize any of this in my current period analysis because there's variables that are not captured here. Well, let me think about that a little deeper then.
And I'm not just saying your initial analysis, but any of your analysis leading to your recommendation.
Oh, I see. Okay. Okay, sure. Different portion of the methodology, and I understand that. Maybe as part of the trend analysis that I would undertake to see what they've historically been awarded and what they've actually been able to attain. Because at the end of the day, I've got to believe that the ROE that is attained is a result of management decision. That's the flexibility that management has for the company to move the levers that produce the net income that is then divided by equity, or average equity is the term I think I heard yesterday, which I would tend to agree with. to come up with that actual ROE. So I'd be concerned, or I'd be curious, maybe is the better term, of what their historic trend is. I don't know how much it would affect my end number though, because again, I like my numbers to stand on their own without any maybe unjustified, if I can call it that, skewing of the final number. And since I don't know necessarily what levers were pulled to produce the actual ROE historically, I wouldn't want to consider that in my methodology.
Do you think you would consider information such as this, whether if staff was trying to determine whether or not to do an investigation?
At the end of the day, these are the dollars and cents, so it's probably the right historic pattern to look at. And anytime you have historic data like this, I think it can help identify trends of one sort or another. And at the back of my mind is always the question, why? So if the question of why is answered, makes me feel much more comfortable with the numbers that we're seeing. Did I get that answer? Did I cover your
It's a
question?
non-answer. I don't think you answered my question, but that's okay, Mr. Tupler. I guess my last question is, again, based upon the last 4 rate cases, stipulating to certain terms and conditions, and largely with regard to the capital structure, the return on equity, and the revenue deficiency. Do you believe that there's any benefit from the commission requiring or suggesting that there be some point in time where there actually has to be a litigated case, a litigated rate case, and you know, instead of a stipulated one?
Very interesting question. As I think through that, I would say my position would be that one of the benefits of a stipulation is the arm's length negotiation and the meeting of the minds of the parties. I think when you have a meeting of the minds, it settles and addresses the major issues, of course, that the commission would otherwise have to adjudicate. I think that meeting of the minds concept is what makes these settlements and these stipulations good at the end of the day. If there's no legal requirement for a contested or case or a adjudicated case, I don't see how a meeting of the minds would be considered detrimental at all.
And I'm not trying to indicate any type of detriment. I'm just wondering if, as somebody who analyzes a lot of data, whether or not you think that, you know, that it might be beneficial to have all of these numbers rather than have a black box and let the company have this discretion that you're talking about, putting this number here and this number here, that, you know, that the commission actually make a determination based upon the information presented in the case as to what is the appropriate number in the appropriate category.
Well, anybody who knows me knows that I am not a big fan of black boxes. It just raises every red flag that my brain has. However, I know that they are a reasonable and justifiable mechanism within a settlement. I'm always curious to peek into the black box, but I don't think that happens. I believe the commission has the authority to do so. And if they chose to exercise their authority, that could be reasonable as well.
Okay, and that's just all I was asking, whether or not you know, you think it might be reasonable at some point for the commission to do that.
I stand on my answer of yes, qualified with the fact that stipulations are a meeting of the minds of all the parties and a very good result.
Okay, very well, sir. That's all the questions that I had for you.
Thank you.
Appreciate your time. Mr. Black, any questions for Mr. Tupler?
Thank you for that opportunity. No questions.
Very well. Any questions from any of the parties? Hearing no questions, you're excused, sir.
Thank you, Madam Examiner. Good day.
I think now might be the appropriate time for us to take our luncheon break. I've got that it's 20 after. So I would propose that we come back at 1:20 and have our remaining witness for staff, Ms. Labor Tercero, testify at that time. And then I think I will hear from the parties regarding any procedural matters that we need to take care of. Okay. All right. We are recessed until 1:20. Remember the YouTube?